All right, let's dive right in. Today we're looking at a legal battle that unfolded over decades, and it asks a really fundamental question about ownership, about time, and about the very ground beneath our feet. So let me ask you this. Imagine pouring your heart and soul into a project for 20 years, nurturing it from a tiny seed into something absolutely magnificent. Could all of that just disappear because of a date on a calendar? Well, for the Shu family in Taiwan, this wasn't some thought experiment. This was their painful reality. And this is the story of their fight for a forest they planted, tree by painstaking tree. To really get what happened here, we've got to rewind. We have to go back to the very beginning. The whole story starts with a piece of land, a family, and, a legal arrangement that turned out to be way more complicated than it looked. Now, the Hu family's connection to this land, it wasn't new. We're talking over half a century, more than 50 years they had been working this land. For them, this wasn't just some random plot. It was a legacy. Okay, so here's where the trouble really starts. You've got three layers to this whole deal. First, the government owns the land, but they lease it out to a farming co-op. Then the Shu family works the land because they have an agreement with the co-op. See that? That little gap created a crucial legal distance between the family and the actual landowner, the government. So in 1996, the family decides to make a really long-term investment. They plant almost 3,000 mahogany seedlings. And you gotta understand, mahogany isn't like corn. You don't harvest it in the season. This is a commitment for decades. They were literally planting a future. For 20 years, those little seedlings grew into a forest. But while they were maturing, a legal deadline was quietly ticking away in the background. A deadline that would put the family's entire life's work at risk. The lease was about to expire. That lease, the one held by the farming co-op, had a hard stop, December 31st, 2017. And when that day finally came, the government just said, nope, we're not renewing. Their position was crystal clear. The lease is over, the land is ours, and so are the trees still standing on it. So, of course, the family sued. But the lower courts hit them with a pretty brutal legal reality. Remember that gap we talked about? Their agreement wasn't with the government, it was with the co-op. That meant, in the eyes of the law, they were just subtenants. They had no direct claim against the landowner. And the whole thing boiled down to this one stark sentence from the court. From their perspective, with no direct contract, the family had no legal standing. The government didn't owe them a thing. It really seemed like the case was over. But they didn't give up. They appealed, and the case went all the way to Taiwan's Supreme Court. And this is where the story takes a fascinating twist. The judges decided to look at the whole problem from a totally new angle. The Supreme Court basically stopped everything and asked a question that changed the whole game. What are these trees, legally speaking? Are they just another part of the land? Or are they something else entirely? Are they a product created by the family? So they brought in this legal concept, the right to fell/harvest. The court argued that, hey, under Taiwan's Forestry Act, the person who actually plants and takes care of a forest, even on someone else's land, might be considered the forest owner when it comes time to harvest. This gave the family a unique right, the right to the harvest itself. The case was sent back down for a retrial. I mean, this was a huge victory. The family now had a powerful legal argument on their side. It seemed like they might finally get their forest back. But the final verdict, it didn't hinge on legal philosophy. It hinged on one simple, irreversible fact. The High Court, in its final ruling, totally agreed with the Supreme Court's logic. They said, yes, the family had the right to harvest the trees. But, and oh man, this is the heartbreaking part. That right only existed for the duration of the lease. They had a window of opportunity, a period of over 20 years, to file the paperwork to harvest the trees. But for whatever reason, they never did. And when the clock struck midnight on December 31st, 2017, that window didn't just close, it slammed shut. And this led to the final, devastating phrase from the judgment. The court wasn't really saying the outcome was fair. It was saying the family had a legal right and a responsibility to act on it, and they just failed to do so in time. The law, in this case, was a stopwatch, and their time ran out. So what's the big takeaway from all this? What's the fundamental legal principle that cost a family their life's work? Well, it all comes down to how the law sees property. This quote from a legal analysis just gets right to the heart of it. Under civil law, things that are physically attached to the land, like buildings or in this case, trees, are considered part of the land itself. They don't have their own separate legal identity until they're severed from it.
Think about it like this. A lease gives you a temporary permission slip to go onto the land and claim its natural fruits, whether that's crops or timber. But it is a temporary right. The second that lease expires, any fruits still attached to the property, whether it's apples on a branch or 1,470 mature mahogany trees, they all revert back to the owner of the land. Your right to harvest just vanishes along with a lease.
And that brings us to the final and kind of chilling takeaway. This isn't just about farming or forestry. This applies to business fixtures you install, home renovations you do, anything you attach to a property you don't actually own. The story of the Shu family is a powerful, powerful reminder to always read the fine print. Because what does your contract say about what you leave behind when the clock finally runs out?